Hello friends, in the series on the income tax cases, today we will discuss a very important issue. The issue is like this, that if at the time of filing of the return of income, if assessee takes a receipt into his income and after that, even after the assessment, if the assessee realizes that that receipt was not taxable, so whether the assessee has an option or the choice at the time of the further proceedings, that assessee can say that by mistake I have taken this amount into my return of income, and although it was not taxable but I have paid the taxes. So whether the appellate authorities at the higher level can consider this point of the assessee. This issue has been discussed by the Delhi High Court in the case of Principal Commissioner of Income Tax versus Ansal Properties and Infrastructure Limited. This case has been reported in 460 ITR at page number 341. The matter has been decided by Honorable Delhi High Court and the date of the judgment is 29th March 2023. In the present case, the assessee is a parent company and the assessee has a subsidiary company in which the assessee owns the whole share capital, and the subsidiary company is an Indian company. There is section 45 which talks about the capital gains, and there is section 47 which talks about certain transfers not to be treated as transfer for the purpose of calculating the capital gain, or in other words certain transactions which are not regarded as transfer. There is a clause 47 clause 4 which says that if a parent company transfer some assets to a subsidiary company in which the parent company owns all the shares, and if the subsidiary company is an Indian company, then the transfer of assets by the parent company to the subsidiary company will not be considered as transfer for the purpose of calculating the capital gain. In the present case, the assessee is a parent company and transfers the trunk infrastructure, which also includes roads, etc., to A Limited, in which the assessee parent company was owning the whole share capital and A Limited was an Indian company, and due to which there was a surplus of near about 70 crore which was incorporated into the return of income by the assessee, that was a parent company, with a note that the assessee has given all the calculation of the surplus, how the surplus was calculated. When the assessment proceedings were going on, the assessee did not realize its mistake at that time also, and even the assessing officer bypassed that mistake of the assessee. But at the time of appellate authorities, when this matter came, the tribunal said that in the present case, the receipt of the assessee was not taxable, and it is a settled law that every receipt is not taxable, and it does not matter if the assessee by mistakes takes that receipt into income, but after a later stage it is being realized that that receipt is not taxable, so the assessee should be given relief. And there is article 265 and section 4 which says that only the real income should be taxed. Article 265 of the Constitution of India says that no tax can be collected or levied without the authority of the law. So if any tax has been paid by the assessee on which the department cannot take the tax, so the department plea before the tribunal that the tribunal does not have the right to go beyond the assessment order will not hold good, and the tribunal said that in the present case the assessee is very much entitled to get the relief of non-payment of tax on that receipt. The department carried this matter to the Delhi High Court. Delhi High Court upheld the order of the tribunal and said that in the present case, since the capital gain has arisen on a transaction which is not regarded as transfer according to section 47, so the amount is not chargeable to tax and there is no infirmity in the order of the tribunal. So friends, this case gives a very insight into those situations where the assessee pays the tax by mistake, so he can take this play at the later stages also. Although the assessee should take care at the time of filing the return that he should file the return properly, but the law is so complex that it may happen that the assessee does some mistake, so that mistake does not enrich the department illegally. At the end of this video, once again, I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus Ansal Properties and Infrastructure Limited, and this case has been reported in 460 ITR at page number 341, and the matter has been decided by Delhi High Court, and the date of the judgment is 29th March 2023.